Good evening, Advocate Pohl.
Good evening, Chief Justice. Good evening, ladies and gentlemen.
For experienced counsel like you, I don't have many questions. For how many years were you junior counsel?
I've been a senior counsel now for almost 2 years, Chief Justice, of the 22 years that I've been practicing at the bar. But I was admitted as an advocate 2 years before that, and I acted then as a state advocate.
Yes. Would you say you are ready?
I think so, yes, Chief Justice.
Yes. JP?
Thank you, CJ. Advocate Pohl, good evening.
Good evening.
You have had several acting stints in our division, haven't you?
That is correct, yes.
You say that in those stints you have covered a wide spectrum of cases?
I did virtually everything that was given to me, as is indicated in my papers, yes.
Were you coping, or were there any particular fields where you experienced challenges or difficulties?
I was coping. Once or twice I had to ask how to do the administrative work that was given, but that is because as counsel you don't do that. But other than that, I had no problems.
On average, how long does it take you to deliver a reserved judgment?
I think the longest it took me was about 2 weeks that it took me to deliver a judgment.
You have had an opportunity of doing circuit court duties?
I did indeed. On both occasions that I acted, I once did the Virginia Circuit Court, and the other occasion I did the Bethlehem Circuit Court.
You did not find it an inconvenience?
Not at all, no.
You were able to function in the circuit court on your own without the assistance of your colleagues?
Indeed so, yes, I did.
Have you also had an opportunity of doing civil pre-trials?
I did, yes, on one occasion.
On one occasion. So you have been involved in case management?
Indeed so, yes, I did.
How did you find it?
I found the purpose, of course, extremely important, and if I may say so, Judge President Mulimela, that under your guidance I can say that I've even heard complaints of attorneys that we are getting dates too soon in the Free State now. We are down to about 2 to 3 months before we can get trial dates, and that is exceptional in the circumstances. I think when I started articles in the 1980s, we had some 2 years lapse before we got dates, and it's down to 2 to 3 months.
Thank you, CJ.
Thank you, JP. Premier?
Thanks, Advocate. I was looking at the recommendations by various stakeholders. I'm looking at the Black Lawyers Association, which says, indeed, you'll make a good judge, and your judgment has been well thought and demonstrate your appreciation of the legal principles. But they say for the sake of transformation, they don't think at this stage you should be considered. Why should you be considered?
Mr. Premier, I think that each of us comprise the diversity of South Africa, and each of us, where you are in life, has a duty to do your bit for transformation, and I think that I have done that. I try to set an example. I try to acknowledge and appreciate everybody that works with me and that gets into contact with me, irrespective of who and who they are. And in that sense, I think I have contributed in that sense, and I will do so in future. And given the opportunity, I wish to continue that.
Continue the process of transformation.
Beg your pardon?
You'll continue the process of transformation of judiciary and society in general. Indeed
so, I will.
Thank you, Premier. Commissioner Singh.
Thank you very much, CJ. Good evening.
Okay. Yes, Premier.
Because we have been posing this question in terms of languages. How many languages can you speak, read, and write?
I'm only bilingual, Mr. Premier. I have some knowledge of phrases in Sesotho, but I am not proficient in Sesotho. If spoken slowly, I can sometimes pick up the line of reasoning, but I am not proficient in any other languages but Afrikaans and English.
You know Dumela, Lekaer,
yes.
You know that.
Thank you, Chief Justice. Advocate Pohl, I see the Black Lawyers Association have also commented that you've acted for approximately 2 terms.
That is correct,
And
Commissioner Singh.
in your questionnaire, I see it's the 4th term of 2013
Yes.
and the 3rd term of 2014.
Yes.
So you haven't had much of an acting stint in the High Court. But they go on to say that he acted for a period of approximately 2 terms, which is less than the required 3 terms. Now, I don't know, Chief Justice, maybe the JP can, is it a requirement that one has to serve 3 terms? Because the Black Lawyers Association say he acted for a period of approximately 2 terms, which is less than the required 3 terms. So I'm just trying to ascertain that.
Except for the Labour Appeal Court, I never acted anywhere before I was appointed. Judge of the High Court, judge of the Constitutional Court, no acting but appointed.
That's an answer. What I'd like to know, Advocate Pohl, acting for 2 terms only, do you think that's prepared you enough to sit in the position of being a judge in the High Court?
Yes, Commissioner Singh, I think it most certainly, let me put it this way, I've been involved in advocacy training for a long time at the bar. And the rationale behind the advocacy training, which we were taught by the English Bar Association, was that no matter at what level you are, there's always room for improvement. So I wouldn't say that I am perfect. I think everybody that's a judge on this panel, if they reflect on their first judgment and the recent judgment, it most definitely do improve. So what I'm saying is there certainly is room for improvement, but I've never found any problem in the times that I acted with anything that was given to me, and I literally got the whole spectrum, so I don't think it detracted in any way from my ability to function properly.
After the 3rd term of 2014 and to date, were you offered any positions to act?
No, Commissioner Singh, what happened was the previous acting judge president asked me whether I would act again the immediate following term, and I requested him to release me from that because of the fact that I was about to take silk, and if you take silk, it's a radical change in your practice, and I wanted to establish my silk practice first, and I've been able to do that since.
Thank you.
Thank you very much, Acting President. Good evening, Advocate Pohl.
Good evening,
Is
Judge
it Le
President.
Pohl or Pohl?
Just Pohl, Judge President.
Oh, okay. Pardon me. Advocate Pohl, I just want to understand what's your take of the transformation agenda of the Constitution?
First of all, the Constitution in Section 174, of course, requires this honourable institution to recommend to the President, broadly speaking, the race and gender composition of the country. So in that sense, it should do so, but it has the proviso, broadly speaking. And being a white male, I think that does not necessarily represent that, but I once again, I say I'm here because of the proviso, and if it's in the judgment of this institution to be recommended, then so be it.
I'm not attacking your candidature.
Yes.
I just asked you what's your take of the transformation agenda of the Constitution.
Well, I think, once again, Judge President, maybe I didn't understand you correctly, but it is, of course, so that the preamble to the Constitution says that we, the people of South Africa, recognize the injustices of the past,
yes.
And inasmuch as the injustice of the past relates to gender and race composition, it should be eradicated, and that's the way I see it.
I see. And whose responsibility is it to ensure that this transformation agenda takes place, it happens?
I think everybody in South Africa, all the diverse people of South Africa, so that we may become united. And if I may say, I recently read the judgment of the Constitutional Court where Chief Justice was described in the city of Tshwane, the municipality versus AfriForum, and in that judgment it clearly came through as well, and I found great guidance in that.
I don't know your background. I regard myself as a PDI, a previously disadvantaged individual. Do you fall in that category?
I don't think so, no, Judge President. I was born in 1959. I therefore had the benefit of the apartheid regime in respect of school education as well as university education, and I consider myself, or the way forward in the way I can perhaps do transformation is to the knowledge that I've gained in that process, to part with that, and to I can't just sit with it. I think it's my duty to now give back to the people of South Africa.
Right. I think that was my next question, to say, if you recognize that you've been privileged in your more than 20 years practicing as an advocate, have you done anything to transform, to assist in the transformation agenda of the Constitution?
Yes, well, Judge President, I think what happened was I was about 35 years of age when the Constitution came into being. I embraced that, and I tried to, wherever, to recognize everybody, to be an example for my colleagues and my juniors especially. I also parted with the knowledge that I had whenever I can or could, and I did so in structured programs and on a one-to-one level with other people that were not that privileged. So in that sense I did. I also took active part in structures within the bar, such as the Fees Committee where we recently really made big strides to get in money so that junior counsel, especially black counsel, could survive economically.
Have you taken any black pupils?
Yes,
How many?
I had one that was allotted to me. It's at our bar, it gets allotted to you, and that person is the longest practicing black member at the bar. He's almost, I think he's about 20 years at the bar now.
That's good. Have you taken any black juniors?
In the 2 years that I've taken SORP, the cases where I had juniors where juniors drew me in, and it did not comprise of any black juniors.
Because you say in your application you specialize in insurance law, law of delicts, felt fire cases, personal injury cases, administrative law, and the law of contract.
That is correct, yes.
So you've never had an opportunity to take a black junior?
Well, not within the briefs that I had,
Yes.
Judge President, yes. Economics and briefing patterns, of course, dictate that, but I've never been involved in a case where the money was of such a nature that I could do so.
Have you done pro bono work?
Yes, I have. For instance, listed in my CV a case where the Supreme Court of Appeal last year asked me to act pro amico. It was a prescription matter, and I did so, and the case is reported in the law reports.
See. Thank you very much, CJ.
Thank you, JP, the good doctor.
In the 70s, when I studied law, I was taught that jurisprudence comes from eminent lawyers like Johannes Foote, Pfaffendorf, John Locke. In the 80s, when I taught law at UNISA for 10 years, I repeated the same story to my students. Now, I'm not aware these days, what are the sources of jurisprudence? Which authors can I quote if I want to quote?
I'm sorry, I'm not quite sure. I didn't hear the beginning of the question, Commissioner. You said jurisprudence in the 70s. Could you just repeat that, please? I didn't hear that quite.
In the 70s,
Yes.
I was taught that the sources of jurisprudence
Yes.
are great jurists like Johannes Foote,
Yes.
Pfaffendorf, and John Locke.
Yes.
Now, in the 80s, I taught law at UNISA for 10 years. I repeated the same story. Now, today, if I were to go back to class, which I intend to do, which ones should I use as the sources of jurisprudence?
Well, I think the Constitution is the supreme law of the land, and that should be, one should look at all law through the lens of the Constitution, first of all. And in doing so, it doesn't mean that one has to jettison all the Roman, Dutch law and whatever, the jurisprudence that you refer to, if I understand you correctly, but one should develop it in accordance with the principles within the Constitution. I think therein lies the gist of the answer that I can give you.
Pfaffendorf spoke about Menschenwürde. He was German.
Sorry, I can't hear again.
Pfaffendorf
Yes.
spoke about Menschenwürde in German. In Afrikaans, it would be Menselijkheid, and it would be humanity in English.
Yes.
And in Setswana or Sepedi or Zulu, it would Ubuntu, Hutu.
Yes.
Would you agree that even before Pfaffendorf was born, African people knew about Menschenwürde and Menselijkheid?
Yes, most certainly. I think what I know about Ubuntu and the principles thereof actually corresponds quite a lot with I'm a Christian, with Christian beliefs, in the sense that it's a humanitarian philosophy, and the way I understand is that I am not because I am, but because you are, and because you are, I am. And that is in the essence what I understand from it. And I most certainly agree that way before then it was prevalent in Africa.
Do you know that what is contained in the American Declaration of Independence and the French, which make equality, freedom, and fraternity, derives from this humanity of Ubuntu?
I wasn't aware of that, no. I wasn't. But
You are
it
not
makes
aware.
sense.
It makes sense.
Yes.
So don't you think that in terms of transformation of our law, before we go into the sky to look for values and principles, we should actually study the indigenous legal thought and find out whether the things that we're looking for in the sky already exist on the ground?
Yes, I agree that if it exists, one should explore it. We are diverse, but in the diversity, a lot of benefit lies, and that in that diversity, if it contains that, then we must explore it. That's why we are who we are, and why we can be such a dynamic nation, I think.
In 1961, the International Commission of Jurists spoke of the rule of law in the African context. Do you think there's a need to contextualize the rule of law?
Once again, in the decision of the Constitutional Court that I've referred to, Chief Justice dealt with that, and he confirmed the rule of law, if I remember correctly, and is within the context, of course, that everybody is subject to the law, and nobody, no politician, no political party, no government organization is above the law. That is the one principle applicable to that.
Eminent jurists like Shackleton, Bezos, Langer, and Zevenza here, Museneke, they ensured that in the interim constitution you have Ubuntu, Botu, as a value. Do you know why it was removed in the final constitution, and whether that was justified?
I do not know why it was removed. I don't think it's justified. As I say, I think it corresponds with logic and humanity, which we must achieve, or try to achieve at least. And in that sense, I think it should be.
I thought you would tell him that in the Tshwane judgment, Ubuntu is there.
Yes, it is there indeed, so yes.
Never been removed. Minister?
I think after this thorough canvassing of the issues by colleagues, I'll defer. Thank you.
Thank you very much, Minister. Commissioner Helens?
Pohl, I've made this joke before. They say, how do you know someone went to Grey Bloemfontein? The answer is they tell you. I see that you told us. On a serious note, could you explain the principle of legality?
Yes, well, legality is in the sense that it must be in accordance with the law. If I think that's the best description that I have, that the action or the deed that is done must accord with the law in broader terms.
And in terms of review, we know that there's a Promotion of Administrative Justice Act, PAJA.
Yes.
Is there a review outside of PAJA?
Yes, well, you have the Rule 53 common law, as it were, procedure of review, but it runs hand in hand, as it were, with PAJA, the way I understand it.
Does the principle of legality come into the law of review?
Yes, indeed, it does.
In what way?
If what is being reviewed is something, let me put it this way: if what is reviewed is being outside of the law and the statute that might govern it, then it comes into play.
Just to conclude, what is your judicial philosophy?
I beg your pardon, Chief Justice?
Judicial philosophy.
I support Ubuntu, Chief Justice.
Judicial philosophy is that you support Ubuntu.
Yes.
All right. You are excused.
Thank you.